Very good afternoon to you and welcome to In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia. This is part of a series of broadcasts which are dealing with the Macedonian question. And in particular, we are covering the research paper published last year titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty. The author, the scholar of this paper is Professor Dr. IGOR JANEV. We have already covered 2 chapters contained in this research paper. And by the way, we've got permission from the author to be able to broadcast this material to you. And we are grateful to him for entrusting us to do so. Chapter 3. Are flagrant violations of the international law with the conclusion of an illegal PRESPA agreement. (3.1) Introductory remarks with respect to legal nature of the violations of the national sovereignty under the nameless conditions and derogated legal personality. The PRESPA agreement, hereafter PA, between Macedonia and Greece was signed by Greece as the first party and Macedonia as the second party on June the 17th, 2018 in the village of Nivici near the PRESPA Lake, Macedonia, under the auspices of the United Nations. This agreement relates to the resolution of long-standing so-called dispute between the 2 countries over the name of Macedonia. The official title of the PRESPA agreement reads, Final Agreement for the Settlement of the Differences as described in the United Nations Security Council Resolutions 817/1993 and 845/1993. The termination of the Interim Accord of 1995 and the establishment of a strategic partnership between the parties. That was in quotation. Indicates that the agreement is based on the accepted or assumed legality of the UNSC Resolution 817 from 1993. As we concluded in the previous chapters of this book, any denomination or so-called reference or so-called provisional name for the state, replacing its constitutional name, could not be a valid legal identity of the state for any legal representation or for contracting process. Taking that legal aspect into consideration, we have to derive a conclusion that the second party in the PRESPA treaty may not be a valid contracting legal identity. And for this reason alone, that treaty should be considered as invalid one. Second party described in the Security Council Resolution 817 from 1993 of the 7th of April 1993 apparently could not be a legal identity for contracting processes, particularly not out of the UN system, since provisional name or reference for the state is by UN definition applicable only in the UN system and not erga omnes or for bilateral treaties. In the United Nations Security Resolution 817 of 1993, instead of the name of the applicant, special formulation was invented with the wording, quotation, state whose application is contained in document section 25147, reducing ID of the applicant to the number of the application for membership. One moment, please. That's better. Now I can see myself. I hope you can too. From a legal point, constitutional name of the candidate, that is the Republic of Macedonia, for the UN membership was hence not recognized by the UN organs. And provisional denomination of the FIREM was used as an artificial provisional designation only for UN purposes, despite the fact that the UN organs and the organization were not legally entitled to recognize states, since the UN organization does not possess this capacity, as we have seen in document UN section 1466 of 1950. For that reason, since the UN Security Council, by bypassing of the name of the state, violated the law of the organization, including the imposition of illegal and limited denomination as one of the additional conditions for UN membership, see previous chapters, we may derive the conclusion that provisional designation was not a valid ID for contracting erga omnes, thus consequently invalidating the PRESPA agreement as a bilateral international treaty. The UN Security Council Resolution 817, 1993, with its invention of bypassing of the name of the state, violated the international law and recommended a nameless state, that is Republic of Macedonia, to be admitted in the UN membership. This is beyond belief. Furthermore, this recommendation for nameless state was adopted by the UN General Assembly, and as a consequence, the state was admitted as a nameless member in the UN. And the story does not end here. For another Security Council Resolution 845, I beg your pardon, with another Security Council Resolution 845, the nameless state that was supposed to be sovereign was subjected to negotiate with the state that actually does not recognize it in order to establish together its name and to be recognized by the UN by the new name, product of negotiations. Therefore, for the same reason as in the case of the Resolution 817, the Security Council Resolution 845, supporting a nameless status and a de facto endless negotiation may not serve as a legal ground for any agreement or treaty. The purpose of the UN Security Council Resolution 845 was to force a state to misrepresent itself and to accept illegal membership status with the nickname, providing a framework for extended pressure aimed to rename the state with an agreement needed to nullify the legal identity of that state. Both the Security Council Resolutions 817 and the Security Council Resolution 845 actually a priori treated Macedonia as an imposter that initially falsely represented itself. Instead of taking into account the international law and principles of peremptory nature, both resolutions establishing illegal nickname and negotiation framework in a preposterous way violated the UN Charter and the basic norms of international law. Namely, judicial personality of any state consists of closed standard set of basic inherent capacities necessary to conduct legal relations. And those basic capacities are same and equal for any state. That is, these are same interconnected essential rights or closed internal set of basic rules intrinsic to sovereign entity as a state. Only those inherent set of capacities, closed by nature and protected, can produce right to contract and be represented in international law and relations. With respect to our case, legal identity pertains to that closed internal set of capacities or rights that are necessary to define the judicial person that conducts legal relations, since without the judicial person does not exist. Sovereign judicial personality is not subject of external revision of the basic capacities as defined interconnected set of norms, since lack of those rights would prevent conducting of the international relation and hence abolish the statehood. In the absence of the judicial personality, a state would cease to be a holder and bearer of international duties, responsibilities, and rights, thus reducing the ability to interaction to level of senseless minimum due to the loss of any accountability for its actions. Beggars belief, doesn't it? The subject matter of the PRESPA Treaty is defined in the preamble of the treaty. Quotation, resolving the difference pursuant to Security Council Resolutions 817, 1993 of April the 7th, 1993, and 845, 1993 of 18th of June, 1993, as well as Article 5 of the Interim Accord of the 13th of September, 1995, in a dignified and sustainable manner, having in mind the importance of the issue and the sensitivities of each party. As we mentioned in the previous discussion above, says the author, Professor Dr. Igor JANEV, any reference replacing the chosen national name creates illegal denomination, such as the provisional one, the FIREM. We should now emphasize that such denomination, replacing the constitutional name and a national name chosen by the people of Macedonia, should always be considered and qualified as an illegal and invalid in all cases, both for states provisional, that is the use as for reference the FIREM, or permanent denomination cases, by agreement or external decision providing for naming or renaming. Such denominations for states, needless to say, have impositional character against the original choice and will of the people or an original choice of the nation as a collective national community with its collective human rights. Hence, the external imposition always creates sense of turning people forcefully into something else, apparently in violation of their inherent rights, that is self-identification and independent self-accomplishment. The violations of Article 1, Paragraph 2, and Article 2, Paragraph 7 of the UN Charter in the Security Council Resolution 817 of 1993 represent a blatant breach or breaches of the UN Charter and general and peremptory principles of international law. Similar conclusion can be derived with respect to the Security Council Resolution 845 of 1993 that apparently violates Article 1, Paragraph 2, Article 2, Paragraph 1, and Article 2, Paragraph 7 of the UN Charter, providing for fake legitimacy of an illegal denomination combined with flagrantly illegal negotiation framework. We note that the UN General Assembly admitted Macedonia to the UN membership, General Assembly Resolution 47/225, 1993. All these things happened in 1993, it seems, on the basis of the Security Council Resolution 817 of 1993, with the additional humiliating conditions therein. The UN basically didn't recognize the sovereign legal identity of the state. And in fact, it participated in the creation of an artificial dispute over national identity of the state and its people, replacing sovereign ID with groundless, limited provisional ID. The UN organs actively participated in the creation of the provisional nickname through admission with imposed fake ID with groundless, limited provisional ID. The UN organs actively participated in the creation of the provisional nickname through the admission with imposed fake ID, FIREM, and after 1993 in the process of renaming nameless sovereign member state with a permanent artificial name, completely disregarding sovereign will of the people in Macedonia and inviolability of judicial personality of a state, including its sovereign identity and dignity. In all UN documents, from its admission, 1993 to present day, the constitutional name of Macedonia was systematically avoided and replaced with humiliating impositional reference, like the country that was admitted to the UN was an imposter with respect to the name that needed a ban for usage, suggesting a fake representation of the alleged imposter state. Unbelievable how things can be, or people can manipulate, even on that level. 3.2, Chapter 3 of the PRESPA agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty, a scholarly paper publication published in 2023 by Professor Dr. Igor JANEV. We are sharing with you today, this day, which is the 26th of February, 2024, Chapter 3. Chapter 3.2 is titled The Legal Grounds of the PRESPA Agreement and the Flagrant Violations of International Law. As we explained in the previous discussion above, says the author, the Security Council Resolution 817/1993, proposing to the General Assembly admission of Macedonia by imposing 2 illegal additional conditions and obligations on the applicant state for its UN admission, after affirming that the applicant meets the criteria for membership laid down in Article 4 of the Charter of the United Nations, they created an ultra vires act, since the resolution of the Security Council 817 is in severe conflict with the advisory opinion of the International Court of Justice, or ICJ for short, of 28th of May 1948, and the General Assembly Resolution A/RES/197/3 on 8th of December 1948. The Security Council Resolution 817 of 1993 is therefore partially illegal resolution, part that contains illegal additional conditions, and as such, this act cannot serve as the valid legal source or a ground for any agreement or a treaty. Same conclusion goes as well for the United Nations Security Council Resolution 845, 1993, that represent merely an extension of legally deficient and defective Social Security Resolution 817 of 1993. In the Security Council Resolution 845, adopted on the 18th of June 1993, after recalling the Resolution 817 of 1993 and considering the Secretary General's report pursuant to it, the Council urged both parties to continue efforts to arrive to a speedily, quotation, speedily settlement of the remaining issues between them. Wow. This Security Council resolution, as we may know, did not exactly have a security character, but it is rather a sort of appeal to the both sides to settle the remaining issues, and as soon as possible. With their request for speedy settlement, it appears that members of the Council, some of them, says the author, understood artificial nature of that dispute, and in order to avoid embarrassment for the UN organs, urged that matter be closed as soon as possible. It is obvious that Greece or their allies in the United Nations organs pushed in the Council for a resolution that avoided resolute wording and only asked for resolving remaining issues, in brackets, minor problem, providing once again that the problem was not even from begging, i.e. from the Security Council Resolution 1993-807. We shall never forget that, 817-1993 of security nature, and that groundless nickname was a mistake and an embarrassment. The Security Council Resolution 817 of 1993 was delivered under apparent misconception of the Council. It was actually demonstrated and proved by later developments when no other Council resolution was adopted for so-called remaining issues with respect of the naming of difference. With respect of the name or difference. Naively, Macedonians for 3 decades believed that the problem with Greece was of a security character, and in the lack of an understanding of the law, blindly continued to negotiate the subject, in quotes, that could not in fact be a legitimate subject of any dispute involving state renaming. What the Macedonian government actually didn't comprehend was the basic principle that 2 states may not have a dispute or a difference, in quotation, with respect to their state's name, and that its name could not be suspended in the UN and replaced under presumption that the country was nameless. As we stressed above, the inherent right of a state to have a name is inviolable, natural right, and that inviolable right can be derived from the necessity that a judicial person must have a legal identity. And apparently that implies that there could be no disputes or, in quotes, differences over the state's name, since this category of judicial personality is not negotiable. As explained in the previous discussion, in the absence of such an identity, the judicial person, such as a state, could to a large extent lose its capacity to interact with other judicial persons, that is, conclude agreements, etc., and independently enter into and conduct its external relations. As explained in the previous chapter, external interference in the form of international act, resolution, decision, agreement, etc., or imposed negotiation seems to be legally completely inadmissible and illegal. The name of a sovereign state as a legal ID or a national name is, thus, an essential defining element of its sovereign judicial personality, both a domestic and an international ID, as in fact, same category or capacity. And as such, essential internal element It is a basic component of its statehood and people's self-determination, as explained previously. The principles of sovereign equality of states with equal attributes and the inviolability of their judicial personality as a closed set of inherent norms, which are common for personality of every state, lead to the conclusion that the choice by a state of its own national name, that is the ID, is a basic inherent right of the state and inalienable choice by the nation alone. As we showed above in previous discussions, it's also an essential part of the right of self-determination, determination of one's own legal identity, i.e., it belongs to the area of basic collective and even individual international human rights, derived from the collective rights, and thus belongs to the domain of jus cogens norms within the corpus of basic inviolable human rights. As we explained above, says Professor Dr. Igor JANEV, external interference with this basic right of state represent an internal interference that is inadmissible. Inadmissible. Apparently, acts of dispositive or written nature, including the UN resolutions or treaties, are void and null and or should not be taken into consideration since they affect essential statehood elements. It is also obvious that if such an external interference with the choice of the national name of a nation state, including name of the national group identity, would be allowed, even through a negotiation process, it might become a legally endorsed mechanism for illegal interference in the intrinsic internal and external affairs of that state, i.e., disabling the capacity to conduct international relations and therefore degradation of its statehood. With the change of the name, state may not be the same international subject as before the renaming, and the very fact of external act for renaming leads to the conclusion that state lost its independence and sovereignty, so that it became a fake state with the fake name. Therefore, the condition for acceptance of a provisional name or denomination is also in violation with Article 83 of the Vienna Convention on the Representation of States in their relations with international organizations of universal character of 4th of March, 1975. Dealing with the issue of non-discrimination of states in these mutual relations. A legal identity or a national constitutional name of a state, by definition, is an essential element of both internal, meaning domestic, and international legal personality of a state, and may not be subject of any intervention, particularly not by external acts such as agreements or resolutions or decisions. The legal responsibility of the United Nations for violation of its charter's provisions stems from the UN duty to respect the basic rights of the states, either as applicants or UN members, and their judicial personality, which are protected by the principles of international law enshrined in the mentioned articles of the UN Charter. Before the conclusion of the PRESPA agreement, I, as a scientist, this is the author speaking, and the author, we know, is Professor Dr. Igor JANEV. I, as a scientist, informed the Macedonian public the judicial redress of the UN Charter violations in the Security Council Resolution 817 of 1993 and the General Assembly Resolution 47/225 of 1993 resolutions can be carried out through the International Court of Justice by reaffirming its own advisory opinion of the 28th of May 1948 and recalling the General Assembly Resolution A/R/E/S/197 in brackets 3 in Roman numerals, of the 8th of December 1948. I should also mention a possibility of suing the UN organization for conducting discrimination in the membership of the UN against one member state when the Vienna Convention on the Representation of 1975 enters into force, which is accepted to occur next year, 2022, says the author. Thus, since the Security Council Resolution 817 represents an ultra-vires act of the United Nations and violates the general principles of international law, the jus cogens norms, it cannot be considered as legally valid ground from which another valid document or act could be created. The legal principle ex injuria jus non oritur. It cannot actually serve as a legal ground for any kind of the so-called ID agreement for renaming a state that appears to be a grave consequence of the final illegal, legal result of the mentioned additional conditioning imposed on the candidate for the UN membership. Similarly, we can derive the same conclusion with respect to the Security Council Resolution 845, providing for baseless, endless negotiation on the subject matter that is strictly in an internal jurisdiction of a state, protecting a nickname given by the UN bodies. As a mere derivation of Resolution 817 and the UNGA 47/225 as decision based on the Security Council Resolution 817, incorporating illegal provisional denomination, that is a nickname for the nameless person or state, any, in quotes, agreement on identity, end of quotes, relating to the change of the national or state identity must always be interpreted and classified as an illegal act, since the national identity may never be subject to negotiations with external foreign subject or organization under any circumstances, says Professor Igor JANEV. Right. Thus, any referring or reference to or invocation of an illegal Security Council Resolution 817 by Macedonian government demonstrated in conclusion or creation of the PA, the PRESPA Agreement, 2018, only prove their misconception and fallacy or delusion that this resolution is in accordance with international law. Only under wrongful presumption that there was nothing illegal with the Security Council Resolution 817, the Macedonian government could naively create or conclude an ill-based PRESPA agreement. Suppose, for instance, that there were no non-universal, I beg your pardon, there were no any universal organization created in our modern era of historical institutional development, such as the UN. Suppose there wasn't one UN organization, 20th and 21st century. In such circumstances, Macedonia would be recognized or not recognized by the majority of nations in the international community, and would never be externally forced or conditioned to change its name, its native identity, by international resolutions, decisions, or imposed conditions by anybody. The only results of such imposed agreements or compromises as a result of previously imposed additional conditions, for instance, as in the case of Macedonia, could only serve as an illegal instrument for cultural negation, denial, or cultural assimilation, actions of illegal nature by definition of the UN and UNESCO with respect to the rights for national and cultural identity, cultural genocide, says Professor Dr. Igor JANEV, the author of this research paper, publication published last year, titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty. And you are listening to In Focus on YouTube with Silvana Pavlovska. Chapter 3, Point 3, the PRESPA agreement and the existing norms of international law and principles covering the rights of the state. In the preamble of the Vienna Convention on the Law of Treaties from 1969, it is stipulated that the state parties of the convention are having in mind the principles of international law embodied in the Charter of United Nations, such as the principles of equal rights and self-determination of peoples, the sovereign equality and independence of states, of non-interference in the domestic affairs, and of universal respect for and observance of human rights and fundamental freedoms for all. In the preamble of the PRESPA agreement, it is also stipulated that the parties of the agreement are, in quotations again, guided by the spirit and principles of democracy, respect for human rights and fundamental freedoms and dignity. End of quotes. And another quote, abiding by the provisions of the Charter of the United Nations. End of quote. However, says Professor Igor JANEV, already in the first sentence of the preamble of the PRESPA agreement, the parties of the agreement are treated as unequal. The first party is identified by its constitutional name, that is Hellenic Republic, while the second party is identified as the state, quotation, which was admitted to the United Nations in accordance with the United Nations General Assembly Resolution 47/225 of the 8th of April 1993, end of quote. This unequal representation of the treaty parties, already in the treaty preamble, is a violation of the principle of sovereign equality. Sovereign equality is in quotation, of the states, and in observance or unobservance of the dignity of the second party. This unequal position of the parties remains throughout the text of the treaty. We shall end it here. We are halfway through chapter 3 of Professor Dr. Igor JANEV's document, important, significant document in English, which we are hoping will enlighten you and give clarity to what has been happening and is still happening, how decisions were made by the United Nations when Macedonia applied to be admitted as a member. Beggars belief, based on my opinion, from what I've been reading thus far. I'm not a legal person, nevertheless, I do have quite a lot of knowledge in the area of the law as it pertains to other aspects of my, or other, vocations and professions that I pursue. So please listen to this broadcast and do continue listening to these broadcasts as we will be covering the remainder part of chapter 3 very, very shortly in a separate live broadcast. We are broadcasting to you on YouTube. The channel is called In Focus with Silvana Pavlovska, and we've been reading to you the document, the publication titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty by Professor Igor JANEV. We are grateful to Professor Igor JANEV for entrusting us to be able to bring this to your attention publicly, wherever you are. Thank you for your attention. I look forward to seeing you shortly. Bye.